Anko, please start.
I can start. Okay. So a grand welcome to all the participants and to all the respective judges, organizers to the final rounds of MediateGuru's second International Arbitration Moot competition of 2022, hosted by the International University of Sarajevo and VIPs in support with Luthra and Luthra law offices. I would start by congratulating all the worthy teams for reaching this far and thanking all the esteemed judges for volunteering their valuable time for this competition. On that note, I would like to take this opportunity to introduce the judges for this round. Our first judge is Mr. Nakul Sachdeva. Since joining Luthra and Luthra law offices in the last 2 years, he has ably advised and represented NHPC in numerous arbitration-related matters. This includes substantive arbitration proceedings, also Section 34 petitions, Section 37 petitions. As on date, the NHPC Limited is one of the largest organizations for hydropower development in India, with capabilities to undertake all the activities from conceptualization to commissioning in relation to setting up of hydro projects. NHPC has a project known as Parvati Hydroelectric Project, which is a runoff the river scheme that is proposed to harness hydro potential of the lower reaches of the river Parvati. Mr. Sachdeva and his team have been advising and appearing for NHPC in all the arbitration proceedings that relates to the said project. They also have another project known as Subsashiri Lower HE project. This project is the biggest hydroelectric project that is undertaken in India so far and is a run-of-river scheme on river Subashiri. And Mr. Sachdeva and his team have been advising and appearing for NHPC in arbitration proceedings relating to the said project. It is an honor to have you with us today, sir. Our next judge is Mr. Madhavendra Singh. He is a Navy commander appointed at Ministry of External Affairs for Strategic International Diplomacy, External Relation and Public Policy. He is a chartered engineer and was heading the Power Systems Specialist Group in the Navy at Directorate of Naval Design. He is also directing the design, analysis, and implementation of future power systems, hybrid energy storage, renewable energy, and electric propulsion. He is a distinguished member of the IEEE and designed the only indigenous sonar simulator and the tactical wargame of the Navy. He is an international arbitrator and a member of LMAAA institutions and other international institutions. He is an author and international faculty on international commercial arbitration, maritime arbitration, blockchain and smart contracts, sovereign immunity. He is on advisory and editorial board of major international and Indian publications. It is also an honor to have you with us today, sir. Our next judge is Mr. Sanjeev Kapoor. He is a partner in dispute resolution of Team Kaitan and Co. Sanjeev. Through a rich and diverse practice that is over 24 years, he has gained invaluable experience in diverse areas of law, including constitutional law, general trade, and commercial laws, laws relating to environment, mining, energy, and infrastructure, and also foreign exchange laws. Sanjeev is also a registered advocate on record with the Supreme Court of India. He is a vice president of ICC International Court of Arbitration. He regularly advises on complex cross-border litigation and multi-jurisdictional disputes. He has a wealth of experience in disputes in the private equity and venture capital investment space and in disputes arising out of joint ventures. It is also an honor to have you with us today, sir. Our next judge is Mr. Manan Shukla. He is part of the dispute resolution practice group of the firm, and his practices focuses on maritime law and domestic and international commercial arbitration and litigation. With over 14 years of experience in the field of dispute resolution, he has independently handled several arbitrational matters. and has also appeared and argued cases before several high courts and Supreme Courts of India. He has significant international experience and has been involved in arbitration proceedings and commercial litigation matters in Dubai, Hong Kong, London, and Singapore. He is also a member of the Young International Arbitration Group with the London Court of International Arbitration, as well as the member of the Young Arbitrators Forum with the International Chamber of Commerce. It is an honor to have you with us today, sir. Last but certainly not least, our next judge is Ms. Fahira Brodlia. Ma'am is a rule of law advisor and project manager for GIZ project dedicated to the reform of investor-state dispute settlement systems in the Western Balkans. She is also the head of the research team of arbitrator intelligence and a lecturer at International University of Sarajevo. As an expert in international arbitration with focus on investment disputes, Ms. Fahira writes extensively and frequently speaks at international conferences and seminars. She is a regular tutor of Chartered Institute of Arbitration Diploma Program. She is a graduate of University of Sarajevo and University of Pittsburgh. Since her participation in the Vismut program in 2015, Ms. Brodlia has been a Vismut coach and advisor for teams from Bosnia and Herzegovina, the Western Balkans, and the US and Myanmar. It is an honor to have you with us today, ma'am. Thank you so much, judges. I will move on to saying the guidelines for the participants right now. So participants, please note that this round has a total of 70 minutes. Each team shall get a total of 30 minutes to present their case. This time will include a time for rebuttal and surrebuttal. Any extension of the time beyond the specified period shall be subjected to the discretion of the judges. The division of time between the speakers is the discretion of the team members and is subjected to the maximum of 80 minutes per one speaker. It is also requested for both of the teams to mention in the chat box how much time they would be reserving per speaker and for rebuttal and surrebuttal. So please do that right now. So after you have done that, I wish the very best for everyone. And with the permission of the judges, we shall begin with the opening statement of the claimant.
Yes, we can do that.
Greetings to the members of the tribunal and counsel for the respondent. In the present proceedings, I will address the tribunal on a procedural and a substantive issue of the dispute on behalf of the claimant. I shall be taking 14 minutes for my submission, and my co-counsel will be taking 13 minutes for her submissions. The claim before the present tribunal is brought by St. Kennard Authority in pursuance of the salvage contract executed between the claimant and the respondent, which is Euro Global Marine Group. The claims pertain to salvage services provided by the claimant to the respondent's vessel Empire of Gold and events surrounding the grounding of vessel that entitle the claimant to compensation and damages. Before beginning with my submissions, members of tribunal, it is pertinent to note that party can approach an arbitration tribunal where the contract specifies that in any dispute, the tribunal should be referred. Also, in maritime claims, they cannot limit their liabilities when they are negligent, and the reward should be fixed according to the criteria to the aggrieved party. Two issues. First, the tribunal has jurisdiction to arbitrate the dispute, and second, the liability of the respondents is limited. I shall now proceed with my submissions if there are no preliminary questions. I cannot hear.
Yeah, none from me.
Yeah, counsel, you may proceed, please.
To proceed with my first submission, the tribunal has jurisdiction to arbitrate the dispute. It has jurisdiction on two grounds stated and as stated by the respondents in their response to notice of arbitration, which are not valid. Considering the first sub-issue, the SCC has jurisdiction rationale temporis. Referring to page number 12 of the Moot compromise, Article 13 of the salvage contract states that parties are barred from making a claim after 1 year from the date on which the party first acquired or should have acquired knowledge of breach, loss, or damage. In the present context, the vessel was removed from the Glencoe Basin Lake, breaching Article 5 of the 2021. And the attempt to collect the compensation for Euro Global Marine was made on 5 separate days, last being 10th April 2022. Following this limit, we have the criteria to approach this court from 5th July 2021 to 5th July 2022. And we have approached this court within the time limit within the 11 months period, which is 1st June 2022 when we served the notice of arbitration to the opposite party. Governing, when we are saying that there is rationale temporis, or there is jurisdiction rationale temporis, we are saying that the claims should be made because Article 13 just says that we have to make claims with the tribunal, but not the tribunal itself, just claims what is stated that we have to make. In the current context, we have made the claims several times on several dates. And by this, we are within the time limit. While considering Article 23 of the International Convention on Salvage, which puts the bar or the limit to take an action within 2 years. And that action we have taken within the years period. So the SCC has jurisdiction claimant since the moment the cause of action has arose, asserted its claim and had attempted to collect the payment. Therefore, SCC has jurisdiction rationale temporis. Considering the second sub-issue that the claimant, am I audible perfectly?
I think all of you are appearing from the same place and you seem to have a little glitch in your internet, I think.
It's cracking in the middle to a certain extent.
And also, we would have liked to hear the respondents, jurisdictional issue first, rather than going for the claimant. Anyway, the organizer should have done it accordingly. So anyways, you proceed now.
I hope I was audible with my arguments, or shall I repeat my arguments once again?
I think we heard the majority part of it and we can extrapolate what we said. So you can probably proceed from here. No problems.
Yes. So considering that we have not barred we are within the time limit that was set, like we made claims under Article 13 of the salvage contract, and we came to this tribunal taking an action against the respondents within 2-year period, which is set under Article 23 of the International Convention on Salvage.
So counsel, claimant counsel, I mean, you're mostly basing your arguments on the international convention, but that's not the special law that the parties have agreed to in. So what is your interpretation from the jurisprudence in the international law vis-a-vis the special law, that is the contract, versus lex generalis, which is the international convention?
We are considering both lex specialis, that is our contract, which is the governing thing here, and we're also considering lex generalis, which is International Convention on Salvage. When we are considering or interpreting the salvage contract concept, which states that in Article 13, claim should be made for the payment, as suggested there, we have made the claim for the payment within the 1-year period, because several times on 10th July 2021 to 10th April 2022, there were a total of 5 claims that we made, which is within the 1-year period that has been set. And when we are relying on the general principle, which says that we cannot take action, which is jurisdiction rationale temporis, we can't come, is 2 years period that we can't take action after 2 years. So within 2 years also we approached the tribunal and have filed the dispute within 2 years. So both the criteria are satisfied in our scenario.
So this, 2-year limitation period in the convention, is it in conflict with the explicit wordings of the contract, or is it not?
No, it is not contrary to it. The contract says making a claim for the payment, and the convention says taking an action against them in the tribunal.
It is invoking arbitration, you're saying?
Yes.
Okay.
Considering the second sub-issue that the claimant is not required to exhaust the local remedies, because Article 1, 2, and 6 of the salvage contract deals with the jurisdiction of arbitration tribunal. These articles plainly set out that all disputes that arise from the contract have to be settled through arbitration. It also provides the applicable procedural rules and the set of arbitration being the Arbitration Institute of Stockholm Chamber of Commerce. The salvage contract uses the word shall, making it a mandatory provision to abide by. And also the salvage contract does not mandatorily stipulate the exhaustion of local remedies. The principle of exhaustion of local remedies exists pertaining to claims against states, or it allows states to remedy their wrongs within their own jurisdiction. It is prerogative of state to waiver this right, and as we want to uphold the contract between the parties, which was said that to approach the arbitration tribunal, we have waived the right of exhausting the local remedies and have came to the tribunal for the solution. Thus,
sorry, counsel, which convention are you referring to for waiver of this right?
We are not referring to any specific convention, but when we consider the customary practice that is considered to approach the local courts first or exhaust the local remedies first and then approach to court. So we have waived that right.
No, so explain to us that, where does it emerge from?
It hasn't emerged. Basically, it is a set practice that has been followed by the usually in the cases, but in commercial arbitration also it isn't followed that much. And also when we are coming here, we are waiving that specific right which usually parties exercise, not under any convention it is established, but it is a customary practice that have been stated.
Proceed, please.
Thus, SCA can pursue arbitration under the salvage contract. If the members of tribunal have no further questions regarding the procedural aspect of this case, I seek permission to proceed with the subsequent submission.
I just have one question on that. See, you are saying waiver, right? But waiver, it's not any kind of a legal right. Either you say it's a trade or a practice, or you say the governing law of the seat states that, or you say some convention is stating that. How can we construe waiver in case you are insisting on the waiver and other side is refuting the waiver?
The claim that is made by respondents is wrong in itself when they are saying that we should have exhausted the local remedies, or there was any right to exercise the exhaustion of local remedies. So in that sense, we said waiver of the rights, but as such, there is no right that we have to mandatorily first exhaust the local remedies. There is no such principle set out that we must have to exhaust the local remedies first. So we are saying that we haven't used that option to waiver or we aren't saying that we are wavering, we are saying we haven't taken the option to exhaust the local remedies first and have approached the arbitration tribunal as set in our contract, which is lex specialis.
No, waiver one can understand in case there was some exclusivity vested in one particular forum, then obviously you could have said waiver, right? In your case, you are reversing the argument. You are saying that because the same. All right. So you are saying because there is no exclusivity, therefore the option lies with you. And if you choose arbitration, then obviously That's your argument, if I understood correctly?
We are saying the seat of arbitration is exclusive. In argumento, we are saying that even if we don't consider the argument that exclusive concept that might be refuted by the respondents, that the exclusive seat isn't with this Stockholm Chamber of Commerce, still we are saying that even if we had the right is with us whether to exhaust the local remedies first or not. So if we have waived that right, coming under the like specialist contract that has set the exclusive forum to SCC, it is the right, the jurisdiction is with SCC.
That's an argument of election, or that's an argument of waiver?
It's an argument of waiver.
All understood. Please proceed.
The counsel, I mean, but just in addition to that, I mean, there has to be a condition precedent which you can waive. So I still do not understand, like, I mean, you would have probably read the memorials of the other side. That's why you're basing that you are this particular thing that they're going to claim it. So you're refuting it right away. But I do not, still I cannot establish where is that condition precedent of exhausting the local remedies come from. I mean, don't take too much time, but I mean, if you can understand what I'm asking, you can just reply quickly.
Yes, I would like to reply, and further, if there are any further queries, we would like to address it later also. Firstly, stating that the waiver, we are saying in the sense that we are responding to the notice that has been given by them. The notice they served that you should first have exhausted the local remedies. Okay. The notice in that they stated.
Please proceed. Yeah.
Proceeding with my second argument, that the liabilities of respondent is not limited. When they are saying that they, when the operations were conducted, the salvage operations were successfully conducted, they cannot limit their liability now for paying, for not paying us any amount. Because under Article 4 of the Convention on Limitation of Liability for Maritime Claims, it is stated that if there is any negligence by the party who is stating that the liability should be limited, or anything that they are stating should not be limited, because if there is negligence on their side, further we are going to prove that that there was negligence on their part, but the liability cannot be limited under Article 4 as an exception to the limitation of liability. Considering the first subpart of it, that is the respondents were liable for negligence, as they did not take due and reasonable care when there was a clear warning that was given by the claimants, that was acknowledged by the respondents, as stated on the page number 10, para 1 of the Moot compromise. That it was earlier predicted that the ship was suspected to be hit by a sudden strong wind, causing the hull to deviate from the waterway and accidentally hit the bottom. In the present case, they did not deviate their ship and continued the same route when they had the option to reroute their ship or take proper precautions while going through that passage. They did not take any due care. And when they are stating that the liability can be shifted to the claimants by stating that the pilots were respondent, is also their fault, because according to Article 4.7 and Article 11 of Rules of Navigation, owners and charterers will be responsible if any accident or damage has been occurred during the transit, owing to the advice of SCA pilot also. Firstly, it is not clearly mentioned that the SCA pilots have given them a negligent or a wrong advice on the first hand. Even if we consider that there has been given any wrong advice to them, still the liability is on the part of the owners or the charterers, in this case, the respondents.
So, counsel, I mean, what statute are you relying on? What convention are you relying on for this? Rules of navigation from where?
Rules of Navigation of St. Canard Authority.
Okay. And what about the call regs?
Sorry, sir?
The collision regulations?
No, sir. We are specifying
collision at sea regulations.
Yes, we are specifying, we are not covering that part, we are covering this part, because it is clearly stated in our rules. When they are taking this passage, they are agreeing to these rules, and these rules are more applicable in the current instance. That's why we are taking these rules in consideration.
Okay. So, I mean, the onus lies only on the captain, or is it shared by the pilot as well? Or is it the pilot which has the complete responsibility?
Pilot does not have any responsibility in this scenario. Only the respondents, the owners have the responsibility because they have their master at the ship and they are having the full discretion over the ship, and they can direct the pilots also if there is any wrong or mishappening that is conducted by them.
Are you sure about it?
Yes. Article 4.7 and Article 11 of Rules of Navigation states that.
Okay.
Also, considering the second limb and concluding limb of my submissions, that even if they are paid any amount, it shouldn't be considered because like the criteria that should be considered while paying the salvage amount should be under the Article 13 of the International Convention on Salvage, which states the criteria for fixing the reward. And in that instance also, we have fulfilled all the criteria because we have used 8 tugboats, Komatsu excavator, and every skill and time that has been used by us, which should be considered while fixing the salvage amount. Also, according to Article 4.4 of Lloyd's salvage arbitration clauses, the amount of any such security shall be reasonable in the light of the knowledge available to the contractors at the time when the demand is made and any further acts which come to the contractor's attention before security is provided. In the present instance, when they blocked the ship, when the ship was blocked and 6 days trade was stopped, they knew that the claims would arise regarding this also when they were entering into the contract. So the respondent was well aware of the fact that the trade was going to be affected because the ship was stuck and could reasonably comprehend the loss of revenue of the claimants. So the consequential damages that claimant faced should be compensated by the respondent. If the members of tribunal have no further questions, I conclude my issues as that the tribunal has jurisdiction and that the respondent is liable to pay the compensation.
So, Claimant Counsel, I just want to ask you a very general question to put things in perspective. So in case a state authority, which is controlling the ports or the Suez Canal, let's say, has prepared a rules of navigation which are in contravention to an international convention, what is the tribunal expected to refer to?
Tribunal is expected to refer to rules of navigation because when they're entering this passage, they're agreeing to all the rules that has been set by this passage.
Is it an implied understanding that anybody who is coming inside is applying to those rules, or is it the international convention that will have an umbrella cover to all these conventions and must have?
Umbrella convention no doubt has a reach to everything, but in the present case, when there is a specific thing, that is when we are saying that contract is lex specialis, in this instance also rules of navigation can be considered lex specialis because it is responsible for the particular route that has been set out. So for this particular route, these rules are applied, and when they are passing through this, they are accepting those rules.
Okay.
Thank you, members, for the tribunal for your time and consideration.
If I may just get some clarity. So you are saying that the rules of the contract of SCA will prevail on the general law.
Yes.
And in those rules, somewhere it's also written as to what are the precautions which are required to be taken when one is navigating through the canal. And there is a rule that in case there is something which is beyond a particular capacity, then you should be using the tugboat.
Yes.
And whose responsibility would it be to call for the tugboat? Would it be the responsibility of the captain of the ship, or it would be the responsibility of the pilot of the vessel?
Both have the responsibility to call for the tugs of the ship, like to call the tugboats.
So if both are not doing that job, which is as per the regulations which according to you will prevail over the international convention, both are deficient in providing the service and both are at fault?
No, both are not at fault, because even if pilots are at fault, they're absolved from the liability from the rules of navigation that is stated Article 4.7 and Article 11. And also providing of tugs is a prerogative of the master to call, because according to Article 55 of the rules of navigation, it is on the prerogative of the master to call for the tugboats if they require any.
And where do we find that rule 55?
Article 55 of Rules of Navigation.
Rules of navigation. Okay. And you say under Article 55 of Rules of Navigation, it's the responsibility of the captain.
Yes, and this will be covered by
calling
my
the tugboat. For calling the tugboat specifically.
Yes.
Or it's generally that navigation.
Generally
or specifically?
Generally, this is the rule, and specifically also in this case, it will be considered. This will be elaborated by my co-counsel.
No. I think I have not made myself clear. Generally, we understand you. Generally, you say that there is a contractual obligation as a result of which obligation passes on from pilot to captain, and captain is the person who is ultimately responsible. So generally, we understand the proposition. Specifically, there is a rule, right, which says that in a particular instance, in case the weightage of a vessel is more than a particular tonnage, etc., then a tugboat is required for helping them and navigating them. That's a specific rule that mentions tugboat. It's not journal, right? So, and I heard you say that you are saying that the deficiency would be on part of both pilot and the captain in case that tugboat is not caught, right? Then you improvise that statement by saying that no, the responsibility ultimately will rest only in captain and not in the pilot, right?
Yeah.
And on that, you are relying upon this rule, which is a specific rule or a general? That's what I want to understand. It specifically deals with requisitioning of the tugboats, or it's a general rule.
It's a general rule. It's a general rule. But when we are going for a specific rule, it says that the ship should be broken down or something. In this scenario, that wasn't the case. So this won't be dealt with, and this will be in detail dealt with my co-counsel.
Okay, great. We'll love to hear your co-counsel on this. Thank you so much. Nothing further from me.
Thank you so much.
Good evening to the members of the tribunal. I would be appearing on behalf of the claimant, Saint Canard Authority. Members of the tribunal, the two substantive issues I would be dealing with are, number one, the respondent has breached Article 5 of the salvage contract, and number two, the respondent is liable to provide the claimant with their due share of damages and loss of reputation. Moving ahead with the first issue, members of the tribunal, I would firmly like to establish that the respondents has removed the ship from the Glen Cove Basin without providing adequate security, which has been lucidly stated as an essential in the salvage contract and the International Convention on Salvage 1989. Article 5 of the salvage contract, which is mentioned in the page 6 of the Moot proposition, clearly states three essential requirements. Number one, the vessel should not be removed from the port or place where it has been brought after the completion of the salvage services. Number two, acceptable security for the salvage award should be provided before moving. And number three, even the salved cargo cannot be removed until acceptable security is provided. In accordance with the above stated article, the respondent was to provide a total amount of $916 million, or the claimant had the right to secure a lien. My client, on this false promise of the respondent to be provided with $916 million, signed the compensation agreement of the amount. The respondent, through this step, did not only commit a breach of contract by signing an agreement which it did not intend to fulfill, but also fraudulently made the claimant relinquish the only right they had to seek their rightful claims and damages through the means of lien. The claimant made 5 attempts to get the claimed amount, but the respondent failed even after that, which clearly reflects bad faith on the respondent's part. Furthermore, the amount which the claimant asked for was an acceptable form of security. Article 21 of the International Convention on Salvage stated that a salver can claim security for the claim, and such a claim shall include interest as well as cost of the salver. As the Empire of Gold was one of the biggest ships, it blocked the canal for a period of 6 days, which increased the expenses and damages of the claimant. Furthermore, the claimant was forced to reroute 320 vessels on either side of the canal, which increased the damages to another notch. Therefore, the amount demanded is conscionable amount in accordance with the above stated principle. Hence, the respondent should be made liable to provide the said amount.
So, counsel, I mean, just tell me that the powers of ship arrest basically emerge from where? Is it the unclosed? Do the coastal states have the powers of ship arrest in cases of salvage?
Sir, it is stated in SCA rules that if we are not provided with adequate security, which is mentioned in Article 5, we do have the right to lien.
No, so that again brings me
Furthermore,
to the earlier question I basically put to your other co-counsel, is that if there is an international umbrella convention to this thing, and your local rules of a particular port authority which have not been read by the ship owners before getting that passage clearance from the port authorities. So what does imply? I mean, your coastal states may have enacted local regulations to arrest a ship in case of a salvage breach, but in case an umbrella convention do not provide for it and provides an international convention or international forum to address it, can the coastal state go ahead and arrest a ship still?
So there is Arrest Convention of 1952 as well as 1999, and it goes in the same. It has the same articles. If we are not provided with a good security, we have a right to lien. So it goes with the Umbrella Convention as well.
So no, right to lien is. I hope you understand. It's a little different from a ship arrest.
Yes, sir.
So that's what I'm asking you. The state regulation enactment, does it provide for a ship arrest under salvage convention?
So salvage is a maritime claim. That is why even the local law as well as the Umbrella Convention does allow this rule that if you're not provided with the security, you do have a right to take the ship unless the security is provided.
Or is this right in perpetuity or is that a time limit?
So in perpetuity.
Okay, please proceed.
Thank you so much. Moving ahead to the second issue, members of the tribunal, the council.
Sorry, I am so sorry. I thought you were addressing this issue a little further. Before you move ahead to the next issue, just one clarification which I wanted. There was a compensation agreement which was entered into between the parties. And you are saying that the security obligations revive and kick in because there was a breach of the compensation agreement. Have I understood your argument correctly?
Yes, sir.
And therefore, you say that you go back to the security, right?
So the argument which I am making is that we were to be paid the total amount of $916 million US, but as the respondents were facing major economic loss because we had the ship with them, to be a little considerate, we accepted the 600 million security and gave the ship on the promise of the compensation agreement, which stated that they are also liable to pay 300 million. And the respondents signed that agreement and agreed to the said amount, but now they are breaching this contract, which is bad faith on their part and is denying our right to money. And we had the only chance to get this money was through the means of lien, which we don't have right now.
Oh, thank you for that clarification. So your case is because the promises made under the compensation agreement were not honored. That is the reason as to why this claim is there, right?
Yes, sir. So I would like to have an extension of 2 minutes to present my case furthermore.
Sure. I think you are getting quite a lot of questions. I think that's a reasonable and a genuine request, and I would assume all my co-arbitrators will agree with that. But just wanted some kind of a clarity. In case you have an agreement which is substituted by another agreement, and then that substituted agreement, which in this particular case is the compensation agreement, that is getting breached, right? then your remedies will, for that breach, will lie under the compensation agreement. How do you then come back to claiming security under the original contract?
So this is an extended contract under Article 1 as well. So when the first contract was not honored properly, that is why we gave them another time in good faith so that they don't face more economic loss. And we expected them to provide us with the amount due to us, that is 300 million. That is why this is an extended contract with the same rules applicable of the first contract.
Oh, so you are saying this is a supplemental to the main, and therefore you go back to main.
Yes, sir.
So then, whether it's a bad faith or not a bad faith, in either case, you are entitled to claim that?
Yes, sir.
All right. So therefore, your argument to that extent of bad faith might not be very relevant.
So it is relevant in this case because the respondents agreed to pay that amount, and when now they are saying that we are not, we don't have enough prerogative or we shouldn't be paid that amount, they are dishonoring the basic contract to which they agreed upon, which is bad faith on their part.
So every breach of contract then would be a bad faith?
Yes, sir.
Okay. Understood. Thank you so much. Nothing further.
Thank you so much. Moving ahead to the second issue, members of the tribunal, the counsel on behalf of the claimant humbly asserts the respondent is liable to provide the claimant with a due share of damages and loss of reputation. As it has been clearly stated in the Article 13F that the reward should include losses incurred by the salvor. The claimant has suffered a consequential loss due to the blocking of canal caused by the respondent's ship, that is Empire of Gold. Even though the ship was steered by the SCA's pilot, we are not liable according to the navigation rules. SCA only provides pilot to help the ship master, but the pilots are not an authority. Furthermore, according to Article 4.7 of the navigation rules of SCA, owners, charterers, and operators are responsible for any mistakes resulting from the pilot's advice of the SCA personnel. Furthermore, Article 5 of the Rules of Navigation states that tugs are placed at the disposal of the master discretion, and SCA is only mandated to provide tugs if there is any defect in the vessel. In this case, the vessel was not defected and was in a perfect condition, nor the master asked for any tugs. That is why the tugboats are not a necessary part in this situation. Furthermore, as it has been lucidly stated in the Moot proposition that due to blocking of the Empire of Gold, a total of minimum 320 ships had to be rerouted because of the ship's large size that has covered the entire width of the canal. This phenomenon resulted in the standstill movement of cargo globally, as the canal is used to carry a total of 12% of global trade. This jam caused a major revenue loss to the claimant. The claimant suffered irreparable reputation loss due to the blocking by the Empire Gold. This reputation loss came in the garb of two different entities. Number one, from the loss of goodwill and trust in the Saint Canard Authority by the vessel owners, movers, etc. And second, by the major media coverage and the global phenomena the salvage operation began. The media covered.
I'm a little confused here. So tell me, SCA is seeking a claim against the ship owners or against the charters?
Both of them, mainly against the ship owners.
And where does the responsibility of the liability for seaworthiness lie with?
Sorry, sir?
The liability of seaworthiness lies with whom? The charterer or the ship owner?
So both of them, mainly with
no,
the
counsel,
charterers.
No. Anyway, you need to brush up on this. Don't confuse the tribunal with these kind of things. Say both, because it doesn't lie with both. Anyway, please proceed. Yeah.
The media covered this phenomena on the scale of it being a global event. This coverage in most of the news had the capability to instill a distrust and bad image for the claimant. Hence, the claimant should be compensated in the form of a reputation loss of 320 million US dollar. Therefore, the claimant pleads before the members of the tribunal to provide with the said damages. I rest my case. Thank you.
Okay,
Sorry.
sorry, I mean, do
I'm
any
sorry,
of
I
you?
interrupted.
No, please go ahead. I mean, I'm just asking if anybody has questions.
Just. I'm again coming back. So your colleague actually said that you would be addressing us on the issues of tugboat. Now, navigation feature rules of Suez Canal, which are being relied upon by the respondent, they mandate, according to them, that in case of any vessel which is more than 8,000 tons load, should be compelled to use a tugboat. In this particular case, it was 22,000 tons, right? So it was much beyond what was mandated under the rules. And I asked your colleague, and I'm asking you also, according to you, whose obligation is it to provide the tugboat? Or because the respondent's case, if I have understood it correctly, and they say is that weather condition monitoring and whether a tugboat should be there or not there, those are the two things which are required to be SCA authorities kind of a responsibility. So in view of the fact that this was 22,000 ton, much beyond 8,000, navigation feature rules required something like this to be steered by a tugboat. Why was tugboat not provided? And in case it was not provided, in case it's admitted that it was not provided, then whose fault it is? Captains or investors?
So, as it has been stated in Article 55 of the Rules of Navigation, that tugs are placed at the disposal of the master discretion, and SC is only mandated to provide tugs if there is any defect in the vessel. In this case, there was no defect in the vessel. Furthermore, when it comes to the size of the vessel, the extra pilots can be provided. That is, if the vessel is over 80,000 SCGT. And the problem is gray in this area if the pilots were provided or not. But the tugboats is not a mandate according to the rules.
All right. So navigation feature rules of Suez Canal, which mandate that 8,000, more than 80,000 tugboat should be provided. You are saying that that mandate is not applicable in this particular case?
Yes, sir.
We can come to the liability later, but that mandate, and why is that mandate not applicable to facts of this particular case? If it's a generic rule, and we have heard your friend argue that contractual rules and SCA authority regulations will prevail over the general law of navigation, why would this rule not be applicable?
So because Article 55 is a part of rules of navigation of SCA itself, which provides that they can increase the pilots, but when it comes to tugboats, it is at the discretion of master. In this case, the master did not ask us for any of the tugboats. That is why it would not be applicable.
Okay, understood. So you are saying the responsibility is of the master of the ship, and since he didn't ask for it, that's the reason as to you did not provide it. All right,
Yes,
understood.
sir. Yes, sir. Thank you so much.
Thank you. Nothing further.
Nothing from my end. I think so. We can proceed.
Nothing in from my end as well. Sanjeev sir covered all.
Okay, so may I request the supervisor to kindly proceed with the respondent's case now?
Thank you. If it pleases the Honourable Tribunal, I shall now present, with the assistance of my learned junior counsel, Mr. Radu, the case for the respondent. Before I proceed to my submissions, I would first like to establish that I am audible and visible.
Yes, you are.
I'm grateful. I shall now establish the issues that have been raised in this dispute, and I shall pose them to the tribunal. These 5 issues are as follows. Issue number 1. Is the claim still within the limitation period and the jurisdiction of the SCC? Issue number 2. Can loss of reputation be claimed? Issue number 3. Does the SCC have jurisdiction to deal with this matter? Issue number 4. Who was responsible for the blockage of the St. Canard Canal? And issue number 5. Was adequate security paid for the release of the Empire of Gold? My junior counsel and I will submit 5 arguments to appropriately solve these issues in due course. The submissions that I will seek to advance are as follows. Submission 1, that the claim has now expired and therefore is outside of the jurisdiction of the SCC. Submission number 2, that irrespective of this limitation period, the SCC does not have jurisdiction over this case. And submission 3, that liability for the blockage of the St. Canard Canal can be apportioned to the St. Canard Authority and not Euroglobal Marine. If it pleases the tribunal, I shall now make my first submission involving the limitation period. If I could please direct the tribunal to page 12 of these supplied materials, you will find Article 13, the salvage contract, within which it is stated that the limitation period to bring an arbitration claim, as agreed by the contract, is 1 year from the date that the alleged breach occurred and that the claimant had knowledge of any loss or damage incurred. As this was a term within the salvage contract, and the ordinary statutory provisions that were set out in Article 23, subsection 1 of the International Salvage Convention 1989 do not apply. I must now demonstrate that the relevant date for the purposes of this limitation period falls outside of the 1 year time limit. The date that the SCA first attempted to collect payment for the salvage contract and were refused was that 10th of July 2021. This is the date that the claimants would have been aware that they had suffered loss as they had allegedly been paid for their services. Allegedly had not been paid for their services. The arbitration proceedings were not commenced until the 10th of August 2022, which means that the claim is out of time by 1 month and therefore no longer within the limitation period. The reason that the date 10th of August is used as opposed to the date of notice of arbitration, which I believe was the 1st of June, is because Article 8 of the SCC rules states, and I quote, that arbitration shall be deemed to commence on the date the SCC receives the request for arbitration. If I could direct the Honourable Tribunal to page 1 of the given proposition, specifically to the second paragraph from the bottom, wherein it states that 8, the SCA, commenced arbitration proceedings on the 10th of August 2022. If one is to apply the exact wording used in the rule to the exact wording used in the given materials, then it can be assumed that the SCC must have received the request for arbitration on the 10th of August, as this is the date that the proceedings were deemed commenced. I shall now make my second submission, unless the tribunal has any further questions.
Yes, please. Just wanting to understand. You have heard the claimant. The claimant makes a distinction. Am I audible?
Yes, sir.
Yeah. So you heard the claimant. Claimant make a distinction between the terminology used in Article 13, which is party may not make a claim more than 1 year. And
yes,
obviously you relying upon SCC clauses which says arbitration shall be commenced. And if I have understood them correctly, they are making a distinction. They are saying that making of a claim is very different and distinct from initiating an arbitration. And claim, according to them, they did make within a period of 1 year. And obviously, claim should not be confused with starting off an arbitration under SCC rules. So what's your answer to that? Would a party may not make a claim? Would you say making of a claim would be equivalent to initiation of the arbitration, or merely a demand would be good enough? If they make a demand or they make a claim from you and then they follow up that with an arbitration within the stipulated limitation period, would that not be good enough? That's the claimant's case. What's your answer to that?
So I would argue that the reason that the 10th of August date should be used rather than the 1st of June, and that the distinction has been made, is because that there is within the supplied materials, it does not state what date that the SCC received the request for arbitration. It only states when the claim was actually commenced. Now, applying the rule given within the SCC, stating that the claim would be commenced when they received that request for arbitration, then it should be assumed that the date that the SCC would have received that request for arbitration would be the 10th of August, as that's the date that it commenced. The notice of arbitration that is referred to within the materials makes reference only to the respondents having received the notice of arbitration, as opposed to the SCC themselves, and therefore that is why I draw the distinction, sir.
All right. So for you, Article 13, making of a statement of claim, making a claim is initiation of arbitration, and not just merely making a claim on the respondent to pay.
Yes, sir.
All right, understood. Please proceed. Nothing further on this.
I'm grateful.
Also, counsel, I would
Yes,
like
sir.
I would like to ask you one question, is that the governing law says the claim would have commenced on the day the notice for arbitration was served. But whereas the SCC rules of arbitration say that it is the date of the commencement of arbitration which the institute would provide. So what should the tribunal rely its decision on, basically?
The tribunal should rely their decision on the exact wording given in the rules, which would be that the commencement would be when they receive a request for arbitration. This, I believe, is a matter of semantics, in that there is a distinct difference between a notice for arbitration, which was received by the respondent, and a request for arbitration, which is to be received by the SCC. However, this request, as far as I'm aware, was not received until the 10th of August. Therefore, that would be when the claim is commenced and when the relevant period would be for the 1-year time limit. Have I answered your question, sir?
Sure, please proceed.
I'm grateful. I shall now make my second submission, which is that the SCC does not have jurisdiction over this claim. Aside from the already established point that the claim is expired, it is in fact Egypt and the Egyptian court who would hold jurisdiction over this claim. This is because the Empire of Gold was put under arrest by the SCA, which is an Egyptian government authority. Article 7, subsection 1 of the International Convention relating to the arrest of seagoing ships states that in the event a ship is placed under arrest, the courts of the country in which the arrest occurred have jurisdiction to determine that case. Egypt is a party to the aforementioned convention, as is Sweden under Chapter 4 of the Swedish Maritime Code. Therefore, the International Convention relating to the arrest of seagoing ships applies to the arrest of the Empire of Gold, and as a result, it is not up to the SCC to decide the instant case, but instead, the Egyptian courts ought to decide it. The reason that the tribunal should deter from the given contractual obligement to act through arbitration is because the International Convention relating to the arrest of those seagoing ships applied prior to the contract, and therefore, upon the arrest of the ship, that would be when the convention would kick in and the contract would be overridden by that convention. Unless there are any questions from my second submission, I shall now make my third submission before passing to my learned junior, Mr. Radu.
I have one question on that.
Yes.
You were saying that arbitral tribunal does not have jurisdiction for the reasons that the state courts have jurisdiction under the statute and the convention?
Yes, sir.
Wouldn't the general law be, and the international principles be, that in case there is an arbitration agreement which is entered into between the parties, then domestic courts will give way to the arbitral tribunals?
This would ordinarily be the result if there was an arbitration clause within the within the contract. However, it is my submission that the international convention relating to the arrest of seagoing ships should override the predisposed argument that the claimant and the respondent, agreement that the claimant and the respondent had within their contract.
No, just for my clarity, I think you are saying that there is no arbitration agreement in the contract between the parties?
Sorry, there is an arbitration agreement.
There is. All right. Oh, I'm so sorry. I heard you say that there is no. So there isn't. So I think the admitted position on both sides is there is an arbitration agreement as far as the contract is concerned.
Yes.
You are saying that arbitration agreement should not be enforced, and tribunal is not having jurisdiction because the state courts have got jurisdiction.
Yes.
Right, and therefore state courts will give way to the arbitral tribunals, right?
The state courts would take
precedence over arbitral tribunal.
They would take precedence over the arbitration if that has been previously agreed under an international convention.
All right. So then in that particular case, arbitration always comes in because of the agreement between the parties. And there's always an option which is available to the parties not to agree to arbitrate. And the state courts would always have jurisdiction in those kind of cases. Any commercial kind of a contract, you can choose an arbitration, you can not choose an arbitration. And in case you choose an arbitration, then arbitration will prevail. In case you don't choose an arbitration, then state courts would have jurisdiction. Are we on same page on that?
Yes, sir.
So if the tribunal accepts your argument that because there is a jurisdiction which is vested with the state courts and therefore they will get precedence over the arbitration, there will never ever be an arbitration which can always be effectuated, because in absence of an arbitration clause, parties would never be remediless. There would be municipal courts or the state courts which would be having jurisdiction to decide their disputes. So why do you reverse this order of precedence and wherein you say that in case state court had jurisdiction, then the arbitral will not be having jurisdiction? Can you just kindly elaborate on that? Because maybe I have not really understood the argument fully.
Yes, sir. In the event that the ship had not been placed under arrest by the Egyptian authorities, then the contract would have been adhered to and arbitration proceedings would have been commenced. However, the fact that the ship was placed under arrest by the Egyptian authorities, that is what's set to the side from an ordinary claim that involves arbitration, which is why the arrest of seagoing ships convention applies in this case, and therefore would override the arbitration claim, or the arbitration clause, sorry.
Is my understanding correct that the ship was actually released later on because there was a compensation agreement which was executed between the parties?
Yes, there was a compensation agreement of 600 million agreed and paid by the respondent.
So is your contention that once the ship has been arrested, even if it is released, then also the state courts would have jurisdiction in perpetuity because at some stage they arrested the vessel?
That would be my contention, yes, sir.
Okay, understood. Thank you. Thank you.
I'm grateful.
Yeah.
I shall now make my third submission before passing to my learned junior, Mr. R.E.A.L, to make submissions 4 and 5. The third submission that I seek to make is in regards to whom was responsible for the blockage of the St. Canard Canal. It is proposed to the Honourable Tribunal that the St. Canard Authority themselves are liable for this blockage and not the respondent. Legally, the master still retains control of the vessel. However, it is submitted to the tribunal that this is merely a legal technicality, and that from a practical standpoint, the pilot was actually in control of the vessel. The pilot is supposed to be more familiar with the port, its waterbed, the water depth, and can better maneuver the ship. It would be unreasonable to suggest that the master should have control of the ship when he has less knowledge of the waterways, the port, and when the pilotage is compulsory. Given that the master's alleged control is a technicality, then the tribunal is invited to use their ability to divert from the conventional approach and deem this legal technicality as inappropriate in the instant cases, as is the tribunal's right under Article 27, subsection 1 of the SCC rules. It is established that the SCA and therefore the pilot hold responsibility for the traffic through the canal. This is a fact admitted by the claimant in the first paragraph on the first page of the claimant's summary facts. Therefore, it is the responsibility of the pilot to ensure that the appropriate safety measures are implemented to ensure safe traffic management. As the pilot's role involves ensuring the safe passage of vessels, then the pilot ought to have recommended the use of tugboats to mitigate the risk of the ship from running aground due to inclement weather. In addition, the Suez Canal navigation rules, specifically Section 2, Article number 11, states that ships of over 80,000 tons are to be given tugboats to assist their passage. The Empire of Gold was carrying almost triple this weight in goods and was the maximum length of vessel permitted in the canal, and so they should have automatically been given tugboats. My learned opposition has helpfully established in their submission that the pilot also holds responsibility for fetching the tugboats. In addition, the article referred to by my opposition, Article 55, in which it states that tugs may be placed at the disposal of masters. They may only be placed at the disposal of masters in the event that the Suez Canal Port Office deems it necessary. Therefore, if the Suez Canal Port Authority does not deem it the San Canal Authority does not deem it necessary, then the master is not at disposal to use the tugboats, and therefore it is not his responsibility. Therefore, the pilot failed to engage in these tugboat services, which directly contributed to the ship being diverted by inclement weather and running aground. It is submitted to the Honourable Tribunal that the pilot failed to provide the appropriate tugboat services or advise the master sufficiently, which caused the ship to be blown off course by a sudden wind and therefore ran aground in the canal. And as a result, the SCA holds responsibility for this blockage and not the respondent. Unless the Honourable Tribunal has any questions regarding any of my advanced arguments, I shall allow my learned junior to submit the final two submissions.
Just one question for me. I think I heard you say that legally, and though you say it's a mere technicality, but legally you kind of acknowledge and agree that ultimately the responsibility lies with the captain. And that, sorry, please.
Sorry, go on, sir.
No, that's it. So if I've understood your argument, you say legally, and you emphasize those words legally, the responsibility would be of the captain in case.
Yes, the master would still retain control of the vessel. However, it has also been established by the opposition that the San Canal Authority holds responsibility for the safety of the traffic and equally for the use of tugboats, as admitted by the opposition.
Right. So if I am understanding you correctly, your argument is in two parts. Firstly, obviously, you are saying that technically it might be the responsibility of the master, but then the safety, weather conditions, and other things, those are the responsibility of SCA.
Yes, sir.
So it's in two parts. I'm not on the second part. I think I've heard you, and on the first part, let's assume that we don't agree with you on the issue of jurisdiction, and we want to go ahead with it. In that particular case, you're saying that though technically master is responsible, but this arbitral tribunal, looking at the facts and circumstances of the case, wherein there was a deficiency in providing some kind of services, etc., by the other side, we should take those facts into consideration and then not grant them in compensation or any kind of damages. That's what your argument is.
Yes, sir.
All right. And where does the tribunal has got that kind of a flexibility? Because it's a creature of a contract, and it has to go by what the regulation rules and the contract says. Where would we, as members of this tribunal, find that flexibility to kind of rule in violation or in face of certain regulations, etc., merely on principles of equity?
Yes, sir. I would first like to establish that Article 27, subsection 1 of the SCC rules would be where you find this discretion. But I would like to make the distinction that there is a difference between Article 27, subsection 1 in my submission and Article 27, subsection 3.
Which page you are referring to? Where is that mentioned?
Apologies. This is not within the memorial. This is stated within the SCC rules. I can read them verbatim if you'd like.
No, I have that. I have the SCC rules. Which provision you saying?
This is on page 21, Article 27.
All right.
The arbitral tribunal in the first subsection, that relates to being able to apply the flexibility of laws as they consider appropriate. Whereas the third subsection, which I believe is what you were referring to in regards to justice and equity, should not be applied, as neither of the parties, as far as I'm aware, have authorized that subsection to apply.
All right. All right. Thank you. Thank you for those clarifications. Very helpful. Nothing further from me.
I'm grateful. I shall now pass on to my learned junior to submit his final two submissions.
May it please the Honourable Tribunal. I'd like to thank my colleague for his introductions and for his submission. As he helpfully cleared out, I will be dealing with the last two issues in dispute, namely whether loss of reputation can be claimed by the claimant, and secondly, whether the claimant was entitled to a salvage compensation in the first place, and if they were, whether adequate security was paid for the release of the Empire of Gold. I'd like to begin addressing the first issue by making reference to the case of Malik against the Bank of Credit and Mahmoud, a House of Lords case decided in the English tribunals in 1991, which remained the leading authority since. In this case, it was decided that the phrase loss of reputation entails that you have made a loss due to your poor reputation. In other words, adaptable more suitably for our situation at hand, SCA's clients must have chosen to use an alternative route or a different canal due to their poor reputation. However, for that to happen, the clients would need to have a suitable alternative in the first place. In the briefing papers, the St. Canard Canal and the Suez Canal are being used interchangeably. I can guide you to the third bullet point on page 10 of the Moot proposition, as well as page 11 of the Moot proposition when this happens again. Therefore, it is safe to assume that this is in fact the same canal. Being the Suez Canal, it is the only waterway which connects the Mediterranean Sea and the Red Sea, and thus Africa and Europe. As this is the only way, and having in mind the business reality of the situation, ships are unlikely to have chosen to travel around the globe just to avoid using the Suez due to their poor reputation, as it does not make any sense financially. To provide the practical view of the matter, going from Africa to Europe or vice versa would take an extra 45 days of constant travel in ideal weather conditions. This would entail advancing over 20,000 kilometers, as opposed to the 20 kilometers it takes to go through the Suez. Therefore, it is submitted that the claim for loss of reputation is unfounded. Moreover, I'd like to make reference to the case of Livingstone against Wayward's Co., another British case which was decided in the Court of Appeal in the late 19th century, in which it was decided that in the case of a loss of reputation, where it is actually proved, the claimant is entitled to, and I quote directly from the judgment, that sum of money which will put the party who has been injured or who has suffered in the same position as he would have been if he had not sustained the wrong for which he is now getting his compensation or reparation. What this means is that they would need to be put in the same position that they were had this wrong not occurred. However, since the SCA is unable to prove any actual loss, and in reality it is unlikely that they suffered any loss in the first place, it is our submission that a sum of $300 million claimed for loss of reputation is too unreasonable. Now, if the Honorable Tribunal does not have any questions for me in relation to this matter, I'd like to move on to the last issue in dispute. The last issue in dispute is whether the claimants were entitled to salvage compensation in the first place, and whether if they were, whether adequate security was paid for the release of the Empire of Gold. The second speaker has helpfully provided that the compensation agreement is an extension of the first salvage agreement. Now, I would like to make reference to Article 17 of the International Convention on Salvage from 1989. In this article, it is stated that the claim for salvage could only be made by a volunteer, meaning someone who was not bound by any pre-existing duty to salve the vessel. In other words, you can do a voluntary act of salvage only if the service was not rendered by virtue of a pre-existing legal obligation, in particular, a contractual or public duty. A pre-existing legal obligation was defined in the case of Lease from 1966, and it was defined as a pre-existing covenant that connects a person with the duty of employing themselves for the preservation of the vessel. Applying this definition to our matter at hand, the tribunal has to determine whether the SCA was under an obligation to work for the benefit of the vessel. My further arguments will illustrate these points for the benefit of the Honorable Tribunal. The question of what constitutes a pre-existing duty has been considered in numerous cases around the world. However, I'll present to you three which are of particular importance to this matter. Firstly, in the case of the Bosnian and Patterson against Gregorio, a 1971 British authority in which it was held that the Harbour Authority was unable to claim for salvage as it was under a statutory duty to use its powers of wreck removal. Quite similarly, the SCA is the port authority responsible for the same canal, and therefore this would entail that they are under a pre-existing duty to salve the vessel. Comparatively, I'd like to present to you a case in which the port authority had no pre-existing duty to assist in removing the vessel, so we could draw a comparison. I'd like to make reference to the case of Vivekananda, a case again decided in the English courts in 2002, in which it was held that the port authority has no pre-existing duty to assist in removing obstructions to the harbor where the emergency takes place outside the harbor. Now, I'd like to put emphasis on this last part of the text. What they're saying is that a port authority has no pre-existing duty only where the emergency takes place outside the harbor. However, drawing for this, the Empire of Gold ran aground inside the harbor and not outside, and therefore the SCA did have a pre-existing duty to assist in resurfacing the vessel. To further illustrate this point, I'd like to make reference to the case of Transit against the MV Cleopatra Drill, a case from 2011 decided in South Africa, interpreting English case law, in which it was held that the port or harbor authority may deprive itself of the status of volunteer because it set out a range of services which it provides in the service of avoiding casualty. They further clarified that they were referring to the employment of a compulsory pilot to send on board the vessels. As the SDA had also provided a compulsory pilotage to avoid accidents, it is clear that they were under a pre-existing duty to assist the vessel. In light of the previously mentioned arguments, we submit that the claimants were under a pre-existing duty to assist the vessel. Moreover, keeping in mind senior counsel's argument in relation to the liability of the accident, it is our submission that the SCA were not just exercising their pre-existing duty, but are also merely fixing their own mistake. Consequently, they were forbidden from making any claim for salvage in the first place. In spite of this fact, the shipping company still acted in good faith and reimbursed the SCA 600 million of their costs, although they didn't have to. as this salvage agreement was void and it should not have happened in the first place, now the issue of jurisdiction also applies here. As they do not have a valid contract in the first place, the express arbitration clause should not apply here. In light of the previously mentioned arguments, the tribunal is invited to consider this, the 600 million they provided in good faith, as reasonable security for the vessel, in accordance with the contract, as the vessel would not have been released otherwise. If the Honourable Tribunal does not have any questions for me in relation to the arguments advanced, I'd like to move on to the prayer.
Just two questions for me. The authority you rely upon makes a distinction of the incident happening inside the harbor or outside the harbor.
Yes. Oh, it's the case of Transit against the MV Cleopatra drill, and it is from 2011.
Right. So I'm sure that must be dealing with a case of a harbor as has been understood traditionally, and not in the I must confess I have not read that judgment, but I just wanted a clarification on that judgment. That judgment must have understood harbor in the normal sense or a grammatical sense as we understand harbor. Here we are dealing with a case which is slightly different. It's a canal and the ship is passing through that canal. How does that analogy of a harbor would be applicable in the facts and circumstances of this case? If you can just elaborate on that.
In the case, it was actually provided that not only the harbor authority, but also the port authority may deprive themselves of this status. Now, the SEA is technically responsible for the Saint Canard Canal and has all the responsibilities that the claimants have highlighted.
All right.
Now, having those responsibilities are awfully similar to what a port authority or a harbor authority would have. And thus, even though there's a distinction between them, they should apply in the same context.
Understood. So you are saying that responsibilities like continuous weather monitoring, maintaining the canal, having a pilot, all those kind of responsibilities which are on SCA would put them akin to a position which obviously would be of a port authority in a harbor, if I have understood you correctly. Understood. Thank you. Thank you. Thank you for that clarification. Nothing further from me.
Now, if the Honourable Tribunal does not have any questions for me, I would like to move on to the prayer. Wherefore, in the light of the issues raised, arguments advanced, and authorities cited, it is humbly prayed that the Honourable Court may be pleased to declare that the International Convention of Salvage from 1989 cannot be relied upon, because the conditions set out in the salvage contract were already agreed upon, and it could be inferred that the parties have intended not to adhere to the provisions in the conventions. Secondly, the SEC does not have jurisdiction to deal with this matter, pursuant to Article 7.1 of the International Convention relating to the arrest of seagoing ships. Thirdly, the SCA was responsible for the accident, as the pilot was practically in control of the ship. Fourthly, loss of reputation cannot be claimed, as there was no alternative method of going into Europe that would make any sense from a commercial standpoint. Therefore, the ships must have continued to use the canal. Hence, the SCA cannot claim damages for loss of reputation. And lastly, the SCA was not entitled to a compensation for salvage, as it was conducting a pre-existing duty. Nevertheless, the tribunal is invited to view the 600 million already provided as satisfactory security given in good faith by Euroglobal Marine. And we're also asking you to pass any other order, direction, or relief that the tribunal may deem fit in the interest of justice, fairness, equity, and good conscience. If you do not have any questions for me further, these have been my submissions on behalf of the respondent.
I just had one short question on your prayer. Are we, as the arbitrators, entitled to decide on the basis of equity and good conscience?
My apologies. No, that stems from Article 27.3 of the SEC rules. However, they also provide that there must be an express agreement between the parties. And from my knowledge, we have not agreed that. So I will be retracting that last part of the prayer.
Thank you.
I'm grateful.
Do we have any rebuttals?
Yes, sir, we do have the rebuttals for this. And for the rebuttals, we have 4 pointers that we are rebutting on. First, we are saying that they are making the claim that the claim under Article 13 is arbitration claim. So they are not reading the contract properly, which states that claim should be made for the payment, which is different from the action that is stated. And when they are saying that making a claim, because they said that making a claim would amount to commencement of arbitration, then when we send the notice of arbitration on 1st June 2022, it is equivalent to commencement of arbitration in their sense when they're referring to the contract itself as lex specialis. Also, they were misleading the court by stating the arrest convention, as Article 7 of the arrest convention explicitly mentions that if there is any express bench set out or the authority of the jurisdiction given to any court, that court has the jurisdiction to decide on the dispute. So under this, the SEC has the jurisdiction to decide on the dispute. Secondly, when we are saying that to reverse the route or through the another route, we are saying that weather conditions could be considered exceptional circumstances when they can consider to reroute the ship, because as they consider delivering goods on time is important, it is also important for them to provide the shipments of the goods in good condition. Both things are necessary, so they can't overrule one over the other when they are stating this part. Third point that I want to say that the claimant were not under the pre-existing duty, because they signed a contract under which we provided the service and because of which we are entitled to get the compensation or the salvage award. And they are saying that once they said the salvage contract is void, and second time they are saying that in good faith of that salvage contract which they are considering as void, they are paying us the amount. So both the things that they are saying is contradictory in itself. Fourth point that we are saying that when they are saying that all the liability is on the SCA itself or everything, rules of navigation clearly absolves the liability of the SCA in those circumstances which were there in the present situation. The counsel for the respondent haven't addressed those points, like how when they are absolved, SCA is absolved from liability, how they can still term that they are responsible for traffic management. Even if we state that we are responsible for traffic management, we did provide you with the warning, we did provide you that there are going to be circumstances which could reasonably be foreseen that they should reroute the ship. These are our 4 rebuttals, and yes, we rest the case.
I believe there are no rebuttal from the other side. Respondents? You haven't provided a time for rebuttal, right?
I believe we provided 3 minutes, although we did run over somewhat. Would the tribunal grant time for a rebuttal?
No, but you said 17 and 13 minutes each, right?
Had we? Apologies, we're just looking at the chat now. Yes, so 3 minutes for a rebuttal. That would be included within my 17 minutes for speaking. But we assume that the 3 minutes for the rebuttal would come after the rebuttal of the claimants.
Okay.
Am I able to offer a rebuttal, sir?
Yeah, please proceed.
Thank you. Regarding, without repeating the same arguments again for the tribunal, I just have just one thing to say regarding the apologies, 2 things to say regarding the rebuttal of the claimants. The first one is regarding the loss of reputation. It is again still submitted that no reasonable businessman would opt to miss out the Suez Canal entirely based solely on the reputation of the San Canal Authority. This is something that would just not make fiscal sense and therefore is completely unfathomable in that respect. Equally, regarding the safety and traffic management of the canal, it was admitted by the claimants themselves that there was this, that they did hold this responsibility, and within that would include tugboats, which would have prevented or greatly mitigated the risk of any form of grounding within the canal. Therefore, the rebuttal given by the claimant that it is unfounded for the respondent to claim that the San Canal Authority had this responsibility is incorrect. I do not have any further sort of rebuttals. So,
thank you. So, may I request the organizers to kindly put the teams into a breakout room so that the tribunal can interact?
Before that, we can thank the teams for their excellent presentation.